Hello everyone, this is Professor Al Merriam, your instructor in Political Science 2030. Welcome back again. Thank you, and it's my pleasure to have you. Today I will be talking about the American presidency. Your authors have several objectives for Chapter 11, the presidency. These include discussion of the evolution of presidential power, an examination of the constitutional and statutory powers of the president. That means the power of the president in the Constitution, and also powers granted to him by Congress. That's what statutory means. It comes from the word statute or law. Third, to explain how the executive office, the vice president, the spouse of the president, and the cabinet help the president in discharging his constitutional and statutory duties. And lastly, the chapter aims to examine how the modern presidency has become powerful. In fact, there's a phrase for that called imperial presidency. That the president has almost, or the presidency has assumed almost monarchical or kingly kinds of powers, simply as a result of the evolution of presidential power and practice over the decades. Now, I have several objectives in the supplemental lecture, and that includes an examination of the constitutional basis of presidential power, which we have looked at when we studied the Constitution earlier in the course. Then we'll look at, in some detail, the role of the Electoral College in presidential election, given the fact that we now have 10 days after the presidential elections. We still don't have a concession by the incumbent president, and things seem to be still up in the air. But it is the role of the Electoral College to make final pronouncements, definitive pronouncements of the winner of the presidential election, and we'll look into the role of the Electoral College in presidential election. Then we shall look at various aspects of the powers of the presidency. Although presidential power emanates principally from the Constitution and laws passed by Congress, there are other presidential exercise of presidential power that have evolved with with individual presidents and the evolution of the presidential institution. And then we shall look at a variety of roles played by the president. First, let's look at the constitutional basis for the presidency under Article 1, Section 1, which we've studied previously. The Constitution sets preliminary requirements, or the only requirements, I should say, for a person to be eligible to run for the presidency. And that is, number one, that person must be a natural-born citizen of the United States, which means that person cannot be a naturalized citizen, which means the person came from another country and went through the naturalization process and became president, must have been born in the United States on U.S. soil. That person must also reach the age of 35 and must have been a permanent resident in the U.S. for at least 14 years. These are the essential requirements: age, citizenship, and residency. Now, Article 2 vests complete executive power in the President of the United States. That means the executive power is the power to implement laws. And so, as we've studied previously, the Congress has the power to make laws, and the President's job is to enforce those laws. And another term for that is execute the laws. And so that is what the President does. The President doesn't make laws. The President doesn't interpret laws and so on. The President gives effect to the laws or executes the laws consistent with the oath he has taken when he became president, and that is a duty of loyalty to implementation of the laws and defense of the Constitution. And the Constitution provides that under the 22nd Amendment, no person shall be elected to the office of president more than twice. That was an amendment ratified after wartime President Roosevelt, and so now there is a term limit on presidents, but there is no term limit on senators or U.S. members of the House of Representatives, because there has been no other amendments. The original eligibility requirements remain without any constitutional amendment or modification. Now, there was some concern with the founding fathers regarding the presidency. You might recall when we studied the Articles of Confederation and also the Declaration of Independence that and the framing of the Constitution, the Constitutional Convention. There was concern that given the colonial history and Declaration of Independence, that the presidency can also attain similar powers as the King of England, and it might be overly powerful, which could result into tyrannical rule. And so they wanted to avoid that. And the second thing they wanted to avoid was to create a national government which is too weak to be able to undertake the task of national government, as was the case in the Articles of Confederation. So they decided to create an independent executive branch with significant limitations on its powers and very few grants of constitutional power. You recall that when we discussed the writing of the Constitution, there were different proposals for a national executive under the New Jersey Plan, for instance, a plural executive being proposed. But the way the framers controlled for any excesses from presidential power was to grant definite and limited powers and broadly empower Congress with legislative authority. Now let's look at the Electoral College, because that's the principal mechanism by which the president becomes president. As I'm sure many of you, if not all of you, are aware, the president is not elected popularly, which means that there is an intermediary body called the Electoral College that formally elects the president. As I'm sure all of you are aware, in the 2020 election, it is reported that former Vice President Biden has 306 electoral votes to incumbent President Trump's 232. And the drop dead date, as it were, is December 14, where the actual votes will be cast. And we shall explore that in a subsequent slide. But let's look at the constitutional mandate with respect to the Electoral College. And the Constitution is reasonably clear about the institution, in that each state is required to appoint a number of electors equal to the whole number of senators and representatives to which the state may be entitled in Congress, which means, for instance, in the case of California, we have 2 senators and we have 53 members in the House of Representatives, which would give us a total of 55 votes in the Electoral College. The Constitution further provides specific guidelines on how the Electoral College conducts its business, and it says that the Electoral College shall meet in their respective states and vote by ballot for 2 persons, and they shall make a list of all persons voted for and of the number of votes for each, which list they shall sign and certify and transmit, sealed to the seat of government of the United States, directed by the President of the United States. So all this kind of cumbersome constitutional language, we shall see in subsequent slides how that actually operates in terms of what needs to happen at specific dates. When you vote for a presidential candidate, you are not actually voting for the president. What you're actually doing is you're telling your state which candidate you want your state to vote for, which presidential candidate, for at the meeting of the electors. It's one of these rather controversial institutions where most people think that when they cast their vote on election day, they're actually voting for the president. And that is not so, and that's one of the rather quirky aspects of American politics, but we've looked at the underlying reasons for the Electoral College in terms of balancing the interests of the smaller states and ensuring that their voices are heard just as well. Now, the states use the general election results, in other words, the results on November 3rd this year, to appoint their electors. Again, all of this is conducted under state law. And the winning candidate, candidate's a state political party, pardon me, political party selects the individual who will be the electors. So here are some critical dates to keep in mind as a matter of practical knowledge as well, because we're heading into that season right about now. So the critical date is the first critical date now is December 8th, which is less than a month away. And on December 8th, the states must make final decisions in any controversies over the appointment of their electors at least 6 days before the meeting of the electors, which will be December 14. This is so that their electoral votes will be presumed valid when presented to Congress. Decisions by states courts are conclusive if decided under the laws elected before Election Day. Now, this is rather important because currently there have been a number of lawsuits filed by the incumbent President Trump to challenge the outcome of the election. It appears many of these lawsuits have not made much progress, and in fact, it doesn't seem that any court has accepted any of the several lawsuits that have been filed. Be that as it may, on December 8th, any controversy involving the votes in the election, whether or not there were irregularities, any of those kinds of things have to be decided. That is mandatory. And if there are any disputes, those disputes will be decided under state law. Now, December 14 is when the electors actually vote in their states. The electors meet on this date, all electors throughout all the states, and vote for president and vice president on separate ballots. And the electors record their votes on 6 certificates of vote, along with other types of certificates. And that is essentially the final act at the state level. The next important date is December 23rd, 2020, when the electoral votes arrive. With the certificate of vote, they must be received by the President of the Senate and the archivist no later than 9 days after the meeting of the electors, which should be around December 23rd. If for some reason votes are lost or delayed, the archivist may take extraordinary measures to retrieve duplicate originals. That doesn't happen often, but they have remedial procedures for that as well. So the next very critical date is January 6, 2021, when Congress formally counts the electoral votes in a joint session. Then the Vice President, as the President of the United States, presides over the count and announces the result of the Electoral College vote. The President of the Senate then declares which persons have been elected President and Vice President of the United States. And after that comes Inauguration Day, which is January 20th, at which time the President-elect and Vice President-elect take oath of office and become formally the President of the United States and Vice President of the United States. So it's a rather complicated process, but that's how it's functioned for decades. Here's an Electoral College map. And what this map shows you is the distribution of electors by state, as you can see. California has 55, Texas has 38, Florida has 29, and so forth. And you can see Minnesota has 10, Wisconsin 20, and so forth. You can see a whole bunch of states have 3 or 5 or 6 or 7. And so it's the large states and the critical swing states that ultimately determine, in most instances, the outcome of elections, and that means that you need 271 electoral votes to become president. And in most states, it's a winner take all. In almost all states, it's winner take all, which means even if the two parties are competitive in a state, the candidate who wins the majority in that state takes the entire electoral vote. There is no proportional distribution. I invite you to watch a couple of YouTube videos, which also give you a more entertaining version of the Electoral College. They're very short. One is 4 minutes, the other one about 10. So on January 20th at noon, the President of the United States is required under the Constitution to take an oath of affirmation. And that of affirmation essentially requires him that he declare the following: that I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will to the best of my ability preserve, protect, and defend the Constitution of the United States. So this oath of affirmation is required, and it is mandatory for any person who assumes the office of President of the United States. The President, the Constitution provides, shall receive for his services compensation, which shall neither be increased nor diminished during that period for which he shall have been elected, and he shall not receive within that period any other emoluments from the United States or any one of them. And this basically says that the President will be working and he'll be paid, but one of the that does not raise any particularly interesting issues. But what has been an interesting issue has been the emoluments clause, or what you see in the next to the last line on the slide. The President shall not receive within that period any other emolument from the United States or any one of them. So the emolument clause has been controversial recently with President Trump's various hotel properties and so on. Some litigants are alleging that he was getting paid, and by the fact that particularly foreign dignitaries and others using his hotel services are in effect paying him, and by doing so they're getting special favors from him and so on. So there is at least one, possibly more, cases filed in federal court challenging the president on the base of the emoluments clause. In case of the removal of the president from office, or of his death, resignation, or inability to discharge the powers and duties of the office, the same shall devolve on the vice president. So basically, if the president is not, for any reason, able to perform his duties, the vice president shall take over. Now let's look at the powers of the presidency. As I mentioned earlier, the president's power emanates either from the Constitution or from the laws passed by Congress. In fact, the constitutional powers of the president are far and few between, and the vast reservoir of presidential power comes from what Congress has enacted by way of legislation. Let's look at some of these key constitutional powers granted to the president. The first one is the fact that the president shall be commander-in-chief of the Army and Navy of the United States. So the interesting thing about that is the president of the United States, who may or may not have any military training or experience, or even have enlisted in the services, is now the civilian commander of the Army and Navy of the United States, the Armed Forces of the United States, which means as the top commander-in-chief, he can command any general, any force, any member of the armed forces as he sees fit. So it is interesting that this particular clause ensures that a civilian is always the top head of the military. This avoids any issues with, for instance, military coups or the military using the armed forces to gain political power. The president also has the power to grant reprieves and pardons for offense against the United States, except in case of impeachment, which means that if a person is convicted of a federal crime, not a state crime or local crime, a federal crime, then the president can grant that person pardon, which means that if the person is given unconditional pardon, it is as if that person did not commit that crime at all. And we'll look at that in subsequent pardon, but it is important to keep in mind that the president has full authority in pardoning or in discharging a person convicted of federal crime from the burdens of conviction or imprisonment, or reduce that person's sentence through commutation, as has been done recently by President Trump in favor of Mr. Roger Stone. The president has the power to make treaties with the advice and consent of the Senate, and that's very important. Advice and consent of the Senate means that in order for a treaty negotiated by the president to become law, because once a treaty has been approved by the Senate or ratified by the Senate, which is the advice and consent process, 2/3 of them, it means that it is law, just like any other law passed by Congress. The president has the power to nominate, again with the advice and consent of the Senate, ambassadors, other public ministers and consuls, judges of the Supreme Court, all federal courts, and other officers of the United States, which are subject to the constitutional requirements. In other words, the nomination process is that the president will submit the name to the Senate, and then the Senate will act on the nomination. Usually a simple majority is what is required to confirm that nomination, and that's how Supreme Court justices are appointed to the bench. The presidency is required, the president, I should say, is required from time to time to give Congress information on the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedient, which means that the president and the federal departments and agencies under him are tremendous sources of ideas for legislation to Congress, but the requirement is that at least periodically the president has to inform the Congress on the State of the Union. On extraordinary occasions, the president has the power to convene both houses, or either one, and with respect to the time of adjournment, and he may adjourn them such time as he shall think proper. So these again do not occur frequently, but it endows the president with such powers. Then, more or less in ceremonial capacity, it is the duty of the president to receive foreign ambassadors and other public ministers, and of course take care that all the laws be faithfully executed, as he pledged to do in the oath of office. Now, the president plays a variety of roles, although he has these kinds of constitutional powers, specific constitutional powers. The president plays a variety of roles which may not be readily perceptible. Plays an executive, legislative, judicial, foreign affairs, and military roles, and we shall look at each one of these in subsequent slides. Now, with the executive function, of course, that, as I mentioned earlier, is the principal constitutional mandate, and by execution of the laws, or the discharge of executive duties, means that it's the president's job to enforce, defend, and protect the Constitution. Do the same with laws of Congress, and from time to time he may issue executive orders as well. So by executing the laws, what we mean is that he's enforcing the laws, he's putting them into effect, he's making sure that the laws are obeyed and enforced, and whatever Congress has intended with those laws, his job is to faithfully execute that. That's a very important phrase, faithfully execute. It doesn't mean that he can interpret and apply or implement it the way he thinks it should be applied. Or the executive role does not lend itself to any kind of judicial interpretive roles or regulatory interpretive roles and things of that sort. It is simply and straightforwardly executing and implementing the laws as faithfully as possible. Part of that, of course, also involves the appointment of all important government officials, because the president cannot do everything by himself. He needs to have officials working for him. And so the heads of the various federal agencies and departments and so on, many of them, have to be appointed by him and subject to the advice and consent of Congress. And of course, the heads of the departments would constitute his cabinet officers. The president, as executive officer, is also the head of state, which means he plays a ceremonial role, both in terms of accepting foreign dignitaries and foreign emissaries, as well as a symbol of national unity. Now let's look at in a more focused way the executive function. An incoming president, for instance, in this case, Mr. Biden, will have up to about 6,000 positions available for him for political appointments, and more likely 8,000 during the period of his term. And these federal appointed positions include ambassadors, members of his cabinet, federal officers, agency heads, and a whole host of other federal executives that are appointed by the president. And the whole idea here is that the president needs his administration, and he should have the people, members of his party or his supporters, or the people that he chooses as members of his administration to help him run his administration and implement his policies and make proposals for new policies as well. So that's one of the essential aspects of the executive office. And in most instances, these kinds of political appointments require a simple majority in the Senate, and the vast majority of them are routinely approved. Conversely, the president has the power to remove any executive officer from office if he thinks that is necessary. Again, these are political appointments. So if the president appoints the attorney general, he can also remove that person. The same with the secretary of state or other federal cabinet members. But he cannot do that to members of independent agencies or other federal officials or top civil service officials and others, because they're governed under different laws. One of the principal sort of quasi-legislative, you could say, as if they're imitating laws, that the president does as part of his executive functions is to issue executive orders. And executive orders are basically directives issued by the president or members of his administration requiring certain acts to be carried out in domestic or foreign situations. President Trump, for instance, has issued numerous executive orders dealing with a variety of issues, many of them involving civil liberties and the powers of Congress, for instance. In the case of sanctuary cities, where the president issued an executive order restricting the grant of federal funds to cities that provide sanctuary to persons living in the country without appropriate visas. Now, these kinds of things in other countries are known as edicts or executive decrees. Now, these executive orders have the same force of law when made pursuant to certain kinds of Congress. Indeed, the power to issue executive orders is granted to the President by Congress, and it provides him for discretionary authority. And the use of discretionary powers by President Trump in the last several years has been very controversial because in certain instances those executive orders go against laws already passed by Congress in terms of, for instance, impoundment of funds or not releasing certain kinds of funds, or reorienting or reappropriating funds that have been set by Congress for one purpose. For instance, using Defense Department money to build the wall. And oftentimes, executive orders are challenged in the courts and reviewed as to their constitutionality, and many of the current president's executive orders have been successfully challenged in the federal courts. Now, beyond the executive powers that we talked about, the president also exercises legislative powers. Again, keep in mind our earlier discussion about separation of powers, which means that each branch of government performs its functions and duties separately. It does not dabble or try to overreach into the other departments in exercise of its powers, because the three branches are supposed to be co-equal and so on. So when we talk about legislative powers of the president, we are sort of using the phrase metaphorically, in the sense that the president is exercising quasi-legislative in the nature of legislation. But clearly, the president cannot directly introduce legislative proposals for consideration in Congress, but that does not mean that he is not part of the broader legislative process, because that is also one of the requirements of executive authority in the Constitution, that he must propose measures to the Congress, and that's an indirect way of shaping legislation. So in the way that the president submits, whether it's the budget or specific ideas for legislation and so on, to the Congress, he is, in fact, providing draft legislation, and it is up to, of course, the formal process for debating and enacting the proposed legislation or the bill is up to Congress. But the idea and the guiding policy originates with the president or in the executive department. So in that sense, they are the president and the executive department is a source of legislation. Presidents and other federal officials, members of the executive branch, in some instances may draft legislation and ask senators and representatives to introduce them in Congress. So in that sense, they become the president or federal agencies become direct source of drafting legislation. In this kind of a quasi-legislative role, the president can influence the legislative branch through constitutionally mandated periodic reports to Congress as well. These reports may be either written or oral, but are given usually as the State of the Union address, which often outlines the president's legislative proposals for the coming year. So the president has a variety of means by which he can play a critical and central role in the legislative process, either by proposing those or even by threatening vetoes, by in effect telling Congress that if they should pass a certain piece of legislation, he'll veto it. That will have a major impact in the way that the bill is drafted and designed, because it takes 2/3 of Congress, both houses of Congress, to override a veto. So there's no point in drafting legislation that's going to be vetoed by the president, with a minimal chance of that veto being overridden. The other area, of course, of kind of legislative role is every bill passed by Congress must be signed by the President, and that is, of course, the President's choice to sign a bill or to exercise the power of veto, which, of course, is that if the President vetoes a bill, he must do so within 10 days. Otherwise, the bill will become law automatically. But if the President vetoes it, as I mentioned earlier, Congress can override that veto by 2/3 vote of each House. Now, if a bill is presented to the President in fewer than 10 days before Congress adjourns, they go home, he no longer has the constitutional 10 days to reflect upon a bill. In this case, if the President remains silent, the bill can still become law, and that is called the pocket veto. If a bill is vetoed in this way, Congress must begin the whole procedure again at the new session, and so the process begins fresh. Now, there's been a question as to whether or not the powers of the veto powers of Congress are total, meaning that he can either accept or reject the entire legislation, or if he can if he can reject parts of that legislation. Well, Congress gave the President what is called line item veto. Basically, gave the President to strike out certain kinds of expenditures in a budget bill. Because there was a lot of earmarks and a lot of pork, as it were, in legislation. And Congress, or members of Congress, did not want to make those hard cuts because it affects their districts. But the Supreme Court decided in Clinton versus New York that the line item veto is unconstitutional. They interpreted the veto powers of the President essentially as the power to accept or reject a complete bill. And so if the President does not like anything about the bill, either he will try to work with it before it gets to his desk and try to make appropriate changes, or he has the power to veto the bill, in which case it can go back and be reworked and be brought back. Or if there is a veto override, then it will become law regardless of his veto. The President also plays sort of quasi-judicial powers. Again, as I mentioned earlier, the power to grant pardons in cases involving federal crimes, except in case of impeachment, is a kind of judicial power. Again, keeping in mind the whole discussion about separation of powers. And the grant of pardon is in effect a judicial act in the sense that the person's conviction is removed, the person is set free, or that person's sentence is commuted or lessened. So in that sense, although it is judges who actually sentence persons convicted of crimes, and under appropriate circumstances, it is the role and power of judges to release persons who are imprisoned without due process of law. In this case, the Constitution grants this kind of quasi-judicial power to the President to intercept the entire process and grant pardons. Also, in terms of appointment of federal judges, again, by appointing federal judges, the President is or nominating federal judges, the President is playing a critical role in the maintenance of the judicial system. And to that extent, he plays a critical role because whoever the President selects will be the person that is going to be presented to the Senate for confirmation. And the President can choose whomever he wishes, and in that way shape the federal courts at all levels. However, the power to appoint does not include the power to remove a justice. And so if the president appoints a federal judge and he doesn't like the decisions of that federal judge, he cannot remove that judge because the Constitution grants guarantees judges lifetime tenure to the extent or as long as they perform their judicial duties in good behavior. And as indicated earlier, courts exercise judicial review over executive order. So in that situation, also the executive order being a type of legislative act performed by the president, then that order is checked by the judicial branch for constitutionality. For instance, in the last few days, DACA, or what is known as Deferred Action for Child Arrivals, the rules were issued by the Homeland Security, and the federal court invalidated those rules, arguing that the acting secretary of Homeland Security is not legally authorized to issue such rules and orders because he has not gone through the appointment process in the Senate. So that person has been in position for over a year and should have been confirmed by the Senate and has not. And so that has now effectively invalidated the DACA rules, which means those individuals who were subject to denial of adjustment under DACA now can litigate their case in federal court, and there are several cases pending in federal court challenging those rules. The president also plays a very critical role in foreign affairs. In fact, there's a major Supreme Court decision which says that the president is the sole organ of foreign policy. In other words, when foreign governments look at the United States, they don't look at the House of Representatives or the Senate and say, we're going to deal with them. They look at the president and the State Department as the principal points of contact in their relations with the United States. So the president plays a central role in conduct of American foreign policy. So in that sense, the president determines the foreign policy of the nation and is responsible for the conduct of foreign affairs. And in doing so, the president does a number of critical tasks. He appoints the Secretary of State, and that is the department that deals entirely with relations with foreign governments, international organizations, and other such institutions. He appoints ambassadors, consuls, and ministers, all, of course, subject to the Senate's approval. So this is the entire institutional mechanism by which the U.S. conducts foreign policy, and that is directly under the president's authority. And more specifically, the president directs diplomatic matters and negotiations on treaties and international agreements and other such things with foreign countries. He receives foreign ambassadors, and as part of that also, it is up to the president to recognize or refuse to recognize foreign governments. The treaty power, the shared treaty power of the president and the Senate are pretty important. Treaty is an agreement concluded between the United States government and foreign governments. And in order for that treaty to have the force of law and become part of the supreme law of the land, together with the Constitution and federal statute, of course, the treaties have to be ratified by the Senate. So, which means that the president's role in the treaty-making process is that the president will draft the treaties with the foreign governments, which means they will write down the language, their agreement, and so forth, and they will prepare the final draft, but that final draft will not have the effect of law until it is acted upon by the Senate. Now, if the Senate does not act, it doesn't mean that that treaty is useless. It could be converted into an agreement, an executive agreement on whatever subject it may be, and it still have the force of law. But it is, if it's elevated to level of treaties, it becomes far more important in the scheme of law. And the appropriate constitutional language says that the President shall have the power, by and with the advice of consent of the Senate, to make treaties provided 2/3 of the senators concur. And that's basically a requirement. Congress exerts control over the executive in terms of passing legislation to implement the terms of a treaty. And so even though an agreement has been made, still Congress has the power to legislate in terms of modifying treaty language and things of that sort. And the law of treaties is governed also by the Vienna Convention, or what is called the Vienna Convention, which deals with the effect of a treaty, the duration, how a treaty is rescinded, and things of that sort. One of the interesting things about treaties is that it may take a very, very long time to ratify them. May not be able to gather the necessary votes in the Senate, and so they may drag on and on before they're eventually ratified. And the reason for that is that senators may have concerns about what those treaty obligations may be in terms of committing the United States to certain kinds of adverse effects, or what they may consider to be a danger or a threat to national security. Oftentimes, minor foreign policy matters are handled in the form of executive agreements, which are easier to negotiate and can be implemented without congressional action. And so those are the executive agreements I mentioned earlier. Now, the President also plays military powers, as we said earlier. That is the Commander-in-Chief of the Armed Forces, which means he is the top boss of all the armed forces, of all the generals. And all of them must take direction and command from the President, because he's the Commander-in-Chief. He's at the very top of the military institution. But there's always been a great deal of constitutional controversy about what the Commander-in-Chief powers means, and one of them has to do with the question or the issue of war. Can the President commit the United States to hostilities abroad, or even engage in wartime activities or warlike activities abroad? Well, the 1973 War Powers Act says otherwise. Basically says that only Congress has the power to declare war, or the congressional power to declare war means that only upon the authorization of Congress can the President actually engage in war. Now, that does not mean that the President cannot send troops abroad to deal with certain kinds of military or political problems and so on, but they would not be considered, quote, war under Article 1, because they have not been officially declared by Congress. And in the War Powers Act, Congress enacted language which effectively checks the President's power to commit U.S. troops to armed conflict abroad without the consent of Congress. And essentially, the Act provides for requirements of notification when U.S. troops are committed abroad, the length and duration of their stay, and additional requirements that if they overstay beyond a certain period, then the President must obtain additional permission from Congress in the form of war powers resolution or some other authority, use of force authorization to continue with commitment of U.S. troops abroad. As the Commander-in-Chief, the President appoints the top military commanders, and he may also remove them from their commands. That's entirely in his discretion. The President may order the armed forces into action within the U.S. And other countries under very limited circumstances, at least internally, domestically. Again, if the President commits armed forces abroad, he is required to abide by the War Powers Act of 1973. The presidential authority to engage U.S. troops does not extend to declaring war, as I indicated, because that power is exclusively Congress's. The management of the military depends upon congressional legislation, for instance, in authorizing conscription or in development of weapons and things of that sort. So, as the commander-in-chief, the president's powers are also limited in the way the broader defense establishment or institutions operate, because there are a lot of laws passed by Congress, including military appropriations, which mandate certain kinds of activities by the Defense Department. Let me cover a few other important powers, some of which we've already covered. I will not take much time. The treaty powers. Again, the power to negotiate those treaties and the need to have the Senate go along or at least ratify those treaties. Executive privilege is one of those important powers that the president has. It's not part of the it is not spelled out in the Constitution, but it is considered to be an inherent power of the president, meaning that it is a necessary element in executive power to have that kind of executive privilege. And what that means is that the president has the right to keep certain kinds of confidential communications confidential, which means in many instances Congress will be issuing subpoenas to talk about whatever issues that they may be interested in. For instance, in the impeachment of President Trump, Congress issued a number of subpoenas ordering members of the Trump administration to come and testify. And the president invoked executive privilege and saying that because these people, these officers or officials have communicated with me certain kinds of confidential information, I cannot allow them to come and testify. And so it's been problematic. And Congress has gone to the courts to enforce their subpoenas because they believe that as part of their oversight functions, they have the right to get certain kinds of information, even though if it's confidential information. And oftentimes they are even willing to receive that information in executive session, meaning that in a session that is not public, where only members of Congress or even members of a particular committee will sit and receive that information. But it is an important power that the president enjoys. Well, inauguration is when the president-elect is sworn into office by the Chief Justice of the Supreme Court, and that occurs on January 20th, exactly at noon. Let's talk quickly about the removal of the president. Impeachment is the only way a president can be removed from office, unless, of course, the president dies or is disabled or unable to discharge the duties of his office for other reasons. And in the impeachment process, which we touched upon when we studied the Constitution, the president is accused of having committed certain what the Constitution considers to be high crimes and misdemeanors. And this impeachment power is divided between the Senate and the House of Representatives. In the House of Representatives, they draft up to what is called articles of impeachment. These are basically the charges, the indictment, as it were, the allegations of wrongdoing by the president, which rise up to the constitutional language of high crimes and misdemeanors. And if the House agrees on articles of impeachment, then those charges, those articles, will be sent over to the Senate, and the Senate will conduct its own deliberations And if the Senate agrees with the Articles of Confederation, with the House that is, then they will convict by 2/3, and then the president will be removed from office. So the ultimate that can happen to a president who is impeached is simply no longer serving in the office of president. There is no criminal penalty attached to that. There have been 3 presidents who've been impeached, and by that I mean the word impeachment here is used, accused, but never convicted and removed from office. So, when the term impeachment is used, it just means that they've been accused. First one was Andrew Johnson, who became president following Lincoln's assassination for violation for what is known as the Tenure in Office Act. Basically, he was impeached for firing officials without approval by Congress. There was a law called the Tenure in Office Act, and he had fired a number of officials, and Congress thought that was such an affront to Congress and a violation of law that they wanted to remove Johnson from office, and he barely escaped conviction. The second president is Bill Clinton, who was charged with perjury, obstruction of justice, and abuse of power. He was also impeached, but he was not convicted in the Senate, and therefore continued to remain president. And of course, more recently, the incumbent president, Donald Trump, was also charged or impeached on articles of impeachment alleging abuse of power and obstruction of Congress. And he too was not convicted by Congress and remained in office and remains in office today. President Richard Nixon was about to be impeached in 1974 before he resigned, and had President Ford pardon him for any crimes he may have committed before or during his presidency, and certainly any crimes associated with the Watergate break-in and related offenses. So the impeachment is an extreme check upon the president, and the process is that a formal accusation is made by the House against not just the president, but any impeachable officer. That could be federal courts as well. The House of Representatives, by a majority vote, may bring the impeachment charges for treason, bribery, or other high crimes and misdemeanors. The Senate, with the Chief Justice of the Supreme Court presiding, acts as the jury and hears the charges. Then the Senate votes on a 2/3 basis to declare the president guilty and remove him from office. Or if it fails, then that's the end of the impeachment process. There's no jail or other criminal sanctions associated with that. So in conclusion, the constitutional powers of the president we've discussed as head of state, chief executive, commander-in-chief, chief diplomat. We also discussed his legislative powers and limitations on presidential powers and impeachment of the president. That's the end of this first part of the supplemental lecture. I will provide a second supplemental lecture on the California executive, on the California governor's office. Thank you for watching. It is now 59 minutes and 5 seconds. Until next time, stay well.